We're back on the record outside the presence of the jury following lunch. The March term of the 2017 grand jury has returned an indictment against Mr. Hickman, charging him with persistent felony offender in the first degree.
I believe that says PFO second, Your Honor, but
Did I say first? I meant
Yes.
second. It says second very clearly. I just misspoke.
Judge acknowledges identity. Or plea of not guilty, wait for more charges.
All right, we will pass that to the trial that we're presently in, bail, ROR. Anything we need to take up before we bring the jury back in?
Your Honor, before I call my next witness, I would go ahead and ask to enter the stipulation as to Mr. Hickman's convicted felon status. I guess in so instruct the jury that they can take us back that he's a convicted felon.
We agree to stipulate to that. Judge, also though, Mr. Elder's he's been asking detectives, what were you involved with, like, were you involved in the investigation prior to the search warrant? I mean, the execution of the search warrant, and I don't know where that's going to. I thought we were going to leave it at. That the search warrant was based on allegations of drug trafficking or whatever it was, and go from there.
I don't intend to get into any of the facts of the investigation itself, as far as what they did to establish probable cause or the use of the informants or anything like that. However, I expect these last two witnesses, Detective Beckham and Detective Speaks, will testify that they did surveil this residence as part of their investigation. I do intend to offer that they saw, over a period of 2 months, the defendant at the residence quite often. Obviously, he's placed into issue whether or not Mr. Hickman was there, and I do think it's relevant to establish that.
And Judge, all I see in discoveries, if they're saying 2 months now, all I see in discoveries between November 8th and November 29th in the search warrant affidavit, but 28th in the detective's investigative notes is when they started, in regards to, they said they did 2 controlled buys at that point, like on November 8th and November 28th.
With the Commonwealth, you're not suggesting that you're going to offer any evidence about a controlled buy with a confidential informant?
No, Your Honor. One, that's privileged. Two, that touches on their efforts to establish the drug investigation, which we're not going into, but he's essentially offered to us, I don't live here, I only visit here occasionally, and to the extent that what they, and that would also implicate hearsay to the extent that we would try to get into anything the confidential informant would have talked about, but to the extent that they were surveilling that residence prior to doing controlled buys and observed Mr. Hickman present at the residence, yes, I do think that's relevant. But no, I do not intend to elicit any testimony regarding the substance of their drug investigation, which would be the controlled buys. That's been excluded under several bases. But the fact of their surveillance is, I think, is relevant.
I think that's appropriate, just so long as his testimony is consistent with what's in discovery in terms of the date range.
If I might have a moment to confer.
And Judge, that's information that I would have been entitled to in discovery, specific dates, in regards to when they set up surveillance and otherwise. And all it says is a controlled buy on the 8th, and it's either the 28th or 29th. Otherwise, for them to say that they didn't think, after 4.5 years, I would have moved to suppress and have standing to talk about either the consent form signed by Stephanie or the search warrant itself based upon a mugshot photo, not even a photo pack. We didn't touch that, so
But I thought we were talking about testimony about the period of time under which the house was under surveillance.
Yes.
Isn't that what we're talking about?
Yes.
But it never says it was under surveillance. It just says that, nowhere does it say surveillance. It simply states that and the dates are incorrect between the report and the search warrant. So the detective's report says two controlled buys between November 9th and November 28th, but the search warrant says on November 29th was the controlled buy, the last controlled buy, and then they got the search warrant on the 30th, and that's when they went in.
All right, well, what's the Commonwealth anticipate the detective's testimony is on the period of surveillance?
I anticipate that he'll say they surveilled the residence from approximately September on through the end of November.
Well, I haven't looked at the investigative reports, but why doesn't the investigative report say that?
I don't want to speak too much on behalf of Detective Beckham, so let me confer with him. I guess more or less what he's telling me, and if I misstate something, then I'll let him speak for himself. But what he's telling me is he put the controlled buys in there in the warrant because that's what he was using to seek probable cause, and that I guess the overall surveillance he did not include. He did not write that down, but they did conduct the surveillance. The earliest controlled buy, according to the warrant, is November the 9th, which would be about 3 weeks before this. So they were conducting surveillance for longer than that, but 3 weeks is how long the warrant says. It's just not something that he put in that he reduced to writing.
Let me see the search warrant affidavit then.
And that's not the search warrant. The search warrant is here.
Well, the search warrant affidavit doesn't apparently say anything about the duration of the surveillance.
And the dates are wrong as well between the investigative.
He can ask him about that.
Well, we're right back to.
I think he's free to impeach him. Well, you didn't write any of that down, but it's still relevant. I don't think.
That's his testimony, and that's accurate. I agree that he's able to give that testimony, and you're free to impeach him based upon what's in the investigative report.
I think I'm entitled to know if he's surveilling, and what he witnessed, vehicles and that type of thing that would go in there. I just can't imagine not keeping records in that regards. He could say whatever date he wants, and how can I impeach him when it wasn't written down and memorialized as well?
That's exactly how you impeach
That's how you impeach him, that he didn't document that in any way, shape, or form.
But what is it? I just don't know. I don't know how to impeach him when I say, there's a steadfast date on November 8th November 9th that says.
Hand me a piece of paper. Detective, you mean to tell me that you've testified in this courtroom that you had this man under surveillance for 3 weeks and you didn't document it in your investigative letter? That's one way to do it.
I understand, but I guess, okay.
Are you saying we're limited to November 9th on? Is that the court's ruling?
No. I'm not going to tell him what he can testify or can't testify to. He's under oath. He knows what's truthful and what's not.
Yes, sir.
And if it's not in that report, that gives Mr.
Absolutely.
McLeod an opportunity to cram that down his throat on cross.
Absolutely. Agreed.
Because that should have been in the report. Should have been in the investigative report. Could have, should have been in the affidavit to the search warrant.
Agreed.
But you can impeach him based upon the investigative report, not the affidavit for the search warrant.
And so at that point, though, he's going to say, I surveilled him, and there was no drug activity, and there was nothing going on.
But the purpose of introducing the evidence is not to prove the drug activity, it's to prove his connection to the residence.
Exactly.
The connection, yeah, and I'm just saying that the connection to the residence is he has 3 children that live there.
Well, that's
your argument. You can argue that.
Okay,
it's not a basis to keep it out, your version of what it says.
But that's the basis that you're going for, is just to establish that he lives there.
You've told us that Mr. Hickman's going to testify.
Yes, and so is Stephanie. But so your basis is that Just to establish that he lives.
I'm not trying to get into the drug activity. I'm trying to get in. We've already established that he was the subject of a narcotics investigation. Pursuant to that investigation, did you surveil the residence? Yes. For about how long? I think Detective Speaks will say it was a while, but I'm not sure. I think Detective Beckham will say approximately 2 months. Did you see the defendant going in and out of there? Yes. How often? Often. Something along those lines. That's all I'm looking to elicit. Nothing about the drug activity.
Not continuing objection, Judge.
Okay, thank you. Ready to bring the jury back in?
Yes.
Okay, Brian, we're ready. 13, remember.
Oh, and if I may get the iPad back.
Just so you know, they said they got his name off of CourtNet, his address off of CourtNet, or a mugshot off of an arrest off of
No
CourtNet.
intention of introducing.
But he's never had an address of 633 Jackson.
It's still hearsay. We've said we're not getting into the one. If we need to, do we need to approach?
We need approach.